If you're new here, I'm Emily D. Baker, the badass lawyer, host of the Get Legit Law and Shit podcast and legal commentator. I've been a licensed attorney for over 15 years, but I'm not your attorney, not legal advice. I am a big fan of the cursey words, so headphones are recommended. This is where the law nerds unite to break down the news stories that you want to hear about with facts, not fuckery. Oh, I wasn't in the stream yet. Professionals here, people. Professionals. I wanted to change the lights to something a little holiday. Like, I don't even have my foot thing. There's a lot of you in here this evening. Hello. We don't normally stream like this on a Wednesday, so hi there. Don't forget to like. If you're new, subscribe. We're gonna get the lights going a little festive. We're gonna chat, and then we're gonna chat about what's going on. And right now, what's going on is I am still waiting for Pacer to update for this filing that is due today. So I imagine that will be up shortly. So we're going to talk about a few other things before we get into it. We're going to do a history of the situation, and we're all going to hang out. We're going to get these lights going. There we go. And then let's do green. Let's do red. You can barely see the ones up above. I need to put another row down here, but we are just going to get into it. So here's what's going on. Here's what's going on. This motion is due today. I imagine it'll be filed and up on Pacer shortly because federal courts sometimes have later deadlines than 5 o'clock standard time. So we are going to see what time this updates on Pacer, but we're just going to be here together and pull it up and do a first look anyway. But also there's been a motion to dismiss filed in the Clark Swanson suit. We haven't gone over it yet, so I figure we might as well pull that up and do a quick look at it as well. I was hoping to do these all together in a like sit down breakdown video, but also it's the holidays. I'm not going to be on the interwebs tomorrow or Christmas and going to be taking a little time off. And since this is incoming, I figure we'll just do a first look all together and here to have a little bit of a chat. So if you are watching on the replay, there will be timestamps down below about when we get to things. No shade on hitting those timestamps. Go ahead and go to what you want to watch, but just like and maybe subscribe before you go do that. Okay. Let's go through. I saw some super chats. There was one earlier that the mods let me know about. So thank you for the one that was in the chat before we hopped in. Hello from London. Life according to Ellie. It's 2 a.m. up wrapping presents. I'm going to be doing that after the stream. Thank you guys for the compliments on the hair. I was trying to curl it a little bit just for fun because it's the holidays. I would normally wear my hair like this to a holiday party. This is my holiday party. This is it this year. This is the holiday party. So welcome in, everybody. I have pineapple booch this evening, which I'm very excited about. Crazy Bubble Monkey just took an Ambien, so I'm about to be unconscious. I'll have to watch later, though. Well, Crazy Bubble Monkey, thanks for the super chat, and enjoy the Ambien, I suppose. You can catch the replay. There will be timestamps. We're all gonna watch together. It's like waiting for like a pre-order to drop. Christina, your hair looks amazing. Thank you so much. It's fun. I'm trying to learn to do things with my hair. It's so much like it's so COVID long. My hair is never this long. It has not been this long literally since like I got married. So I am trying to figure out what to do with the hair with it being this long. It's very strange. So yes, this is our little Law Nerds holiday party. I've got my Trust Me, I'm a Lawyer shirt on. I got asked if I saw Truth Sleuth's video. I saw that she posted a video about the Swanson stuff. I have been reading, full transparency today, I have been reading the A, trying to do holiday stuff, but B, reading the Hayley Paige stuff. There are so many documents in that. And I'm going to be doing a sit down to camera, not live video on the Hayley Paige. She's the wedding dress designer that lost her Instagram to the company, but the company like went through all of the fact that it was a company Instagram, and like the company had her, had the passwords to it. Like if y'all ever had your boss have your Instagram password, let me know. I'm curious. So I did that. I had a podcast interview today that I gave for a podcast that will be coming out soon regarding Tom and Erica Girardi. So it has been a lot of stuff today. So as we are waiting for this to update on Pacer, which is the website where all the federal filings go. See, this is why I don't wear my hair down, because then I keep touching it. As we are waiting for this to update, we're going to chat. I'm going to pull up those other documents. We'll just breeze through them and take a first look together. It's going to be a Lawyer Reacts Live. We're gonna cruise through some shit and we're gonna talk about it. Kanta said, hello, dear Emily, love from Peru. Thank you so much. Hello, Trish Fox. Have you heard about the potential California tax that will follow you for 10 years if you move out of state? I have heard about that. I don't know how they're going to enforce that. Also, I hope they're not going to try to make it retroactively, because I don't want to have to do lawsuits against the government, but that's a very California thing to do. We'll see if it actually passes, and we'll see if it's legally enforceable. Because I imagine other states would be like, no, you can't still personally tax people for 10 years of income after they leave. Like you can't do that. But there is a lot of people moving out of California. People get to vote with their feet, just like they get to vote at the ballot box. Newsom shouldn't be surprised. Michael, thank you. So many were here 3 hours before and chatting it up. Thank you, Emily, for this wonderful community. Oh, Michael, that makes me so happy. This community is literally everything. It is literally everything. I can't tell you how much I love being here with you guys. It's why I sign off 17 times. It's because I really do love streaming. And I'm going to go catch some of the other comments. Nate, thank you so much. You guys, thank you for the support of the channel. If you are coming in, just let us know. If you're in the States, what state you're in. Nothing needs to be more specific than that. And if you're international, where you are watching from. And I'm going to try to get some of these questions while you guys start to say hello. So good to see you that are coming in on Facebook as well. Don't always stream on Facebook, but I do sometimes. Judy says, I'm so tired of wearing my hair in a ponytail every day to finally grow it out and now have to wear a head cap every day. Fair enough, Judy, fair enough. Yeah, this is literally just haven't cut it because of COVID. Because of COVID. So Michelle was saying you're lucky Real Housewives of Orange County isn't great this season since you're premiering at the same time. Oh, I forget. I watch everything on Hulu, like when I forget what time TV's on. I used to know like all my favorite TV shows, and my husband and I used to love like a Thursday night lineup. We would watch Survivor and then ER, and we loved it. So I knew all of the things, but because I watch everything on Hulu or literally YouTube, I don't know what time anything comes on. But Orange County, like watching Emily, the lawyer on Orange County, go through COVID was super relatable. But other than that, I'm just like, oh my God, you guys are being mean to Bronwyn. She's clearly going through something as a alcoholic in recovery. I don't know if being on a television show interacting with others that are drinking 30 days into sobriety is a great idea for anyone, but I imagine that would be a hard journey to go through. So it's interesting, but yes, thank you. I will watch Housewives later with regard to Orange County. Shannon, thank you. I love bullet journaling. I love journaling. It is that time of year where I sit down and start doing all of my like new year planning. And this year I've been behind on everything. So I'm just like, great. I'm behind on everything. I haven't done that yet either. We're going to make it work. Chartruth Seeker says 2020 COVID-19 hair. Yes, I watch a number of Pokemon Go YouTubers because I love Pokemon Go, and Trainer Tips Nick is one of my favorite. He also rolls around where I used to work. He lives in Long Beach, California. The areas where he visits are very near the Long Beach courthouse that I used to work in, and his COVID hair is smashing, and I love seeing it. So my kid's COVID hair was a thing, but in Tennessee we do get haircuts. Well, they do. I have not. I don't know. It's weird. I love my hairdresser so much, and she's been my hairdresser since I moved back to California from Washington State in 2000 and 2003. And so trying to find a new hairdresser feels overwhelming. I'll do it eventually. So I want to make sure I see the super chats that are coming in, and then we're going to just jump into these the lawsuits. Law folks. We're the law folks. We're going to talk about the lawsuits, and then I'll go over and refresh Pacer again and see what's going on. So Rich, thank you so much. Let me go. I missed the chat. Totally jumped it. I missed some super chats. I'm sorry. Lori Smith. Hello, dear Emily from Washington State. Hello, Lori Smith. We're all waiting on your state right now. Thank you so much for the super chat. Rich, thank you for the super chat. We're getting this party started. And then I'm going to timestamp it for everybody on the replay. So Backwoods Barbie, I think Bronwyn is still hiding a lot. I mean, the news has reported on a lot of the stuff she's going through. So I'm not going to, I think there's a lot going on. Jennifer says, I still play Pokemon Go too. I love Pokemon Go. Taylor RS, what is your favorite season or player in Survivor? Would you ever go if given the opportunity? I would never go on Survivor. Look, I am a diva. I don't try to be. I like camping for a few days, but I need bathrooms. I need toilets. I need toilet paper. I do not eat weird things. No, I do not like bug bites. And I get allergic reactions to almost everything that bites. Like Survivor seems like hell. But we're like OG Survivor fans. And I loved Rob Mariano. Like he was one of my favorite Survivors ever. So anyway, I like it. Tassie, I'm going to do a purse collection someday. We will absolutely do it. We will do a purse collection. Hi, Adam. Good to see you. Let me make sure I get these super chats, and then we're going to jump into the Clark Swanson motion to dismiss. We're going to juxtapose it a little bit with the motion to dismiss that KJ's team filed, and we're going to refresh Pacer and see if this is in yet, because it should be. Everybody's like still not up. It should be. I mean, it's 8:15. 8:15 Central, so 6:15. It should be up. Thank you, Truth Sleuth. It should be up, but we're going to go over the other ones first. Truth Sleuth also has a video going through these, and we're going to break them down. Michael, yes, I like glamping. I do like glamping. Tay Smith, there's a lot of people from Pittsburgh. That's so good to see. It's so good to see you guys coming in. Would I talk about the Epstein case? Yes, it's a lot. There's a lot there in the Epstein case. So keeping up with things is a thing, but some of these things are taking more research. Like there's a lot going on in the Tasha K. Cardi B case, and that's kind of next up on the list. But we are putting together a form where you guys can fill in suggestions. It's almost where you can fill in suggestions for topics, and that'll be up, and I'll start linking it in the videos so that you guys can absolutely let me know what you want to see. And then the channel members get to vote, which is fun. Piggy, how would a restraining order work if that is something Tati Halo would decide they want to have against? So we can talk about restraining orders in the context of like the Hayley Paige case, because it depends on what it's regarding. So in the Hayley Paige wedding dress designer case, the temporary restraining order that's been issued in that case is against her Instagram account, right? Let's just pull it up for visualization, because I do better with examples versus like hypotheticals, because it's hard. It's like, well, if it's this, then it's this. And if it's that, then it's that. But with a real example, like again, the Hayley Paige case, we can just talk about it. So let me pull up her Instagram. That's Pacer. You guys don't need to watch me pull up Instagram. Let's just pull it up. Also, the last time we were talking about Trisha Paytas's Instagram. I think she is, because it's like gone. I don't think she's locked out. I think she's actually banned from Instagram. And I was talking to a number of people in the like sexual health space, and this is going on the Instagram space, and people who have and promoted OnlyFans are getting lopped off of Instagram too. So I think she got culled in all of that. And I wonder if they will get her second account. But let's pull up the Hayley Paige account that is the subject of all of this, because as I was going through this today, reading through all of the stuff from the company has said that this page, so let's just add this here. The company has said that this Instagram account was a business marketing Instagram account. It was started because of her employment contract with her JLM Couture. And then it goes into the fact that they had the password to it, that how much money they put into building it, that she had reached out to them and asked them to hire a manager for the account because it was getting very busy. And then at some point, she kind of changed direction, and they have a bunch of exhibits posted to their motion that I will break down. But she started posting other content that wasn't the wedding content, and particularly sponsored content. And JLM's argument is that this sponsored content, I actually use this brand for some stuff, but that this sponsored content promotes a relationship between JLM Couture and between these other companies, but they were never given that opportunity. And she was selling sponsorships on her Instagram that has over 1 million followers, but that the business really owns this Instagram, and the business was the one that paid for it. Like, half of this motion for the temporary restraining order read like this: bitch, we made you. Bitch, we made you. Like, throughout the entire thing, it's like, but we made you. And this is how we got you opportunities on this. And this is how we got you opportunities on this. That's how it read to me. And that is what the basis is with this Instagram account, that the breach was because she was using this account now as an influencer, and they threw some definite shade in there going, and she's acting like she's an influencer. Well, yeah, but the business owns the Instagram account. And so that's what the temporary restraining order is over. And the court said, based on what we have now, the damage that can be done is enough that we're going to give the company control of this particular Instagram account until we sort it out. So that's the restraining order that's issued here, is restraining her from operating this Instagram account, from locking them out of the Instagram account. So she's been forced to give over this business Instagram account. And there's a lot, we'll do a whole breakdown on the tea that's within that, but they're not wrong based on the employment contract that was brought up. So this just jumped really, really quick. And I hope I didn't miss anybody's super chat. I need to get to these faster. I'm trying. Lauren, hello from Connecticut. Love my Revlon dryer from your Amazon wishlist. Girl, love it. Thank you, Lauren. Isn't it the best? It's the best hairdryer ever. Y'all, if you're in the chat, if you're watching right now, the Amazon shop has the stuff that I love, and it has that hairdryer. We're going to jump real quick, and then we're going to get into law shit. But it is this hairdryer right here. It's so good. It's so good. It literally, it makes life everything. That's the counter I use back here. But this hairdryer is life. It cuts time. It's easy. It doesn't like hurt the shoulders when you're trying to dry your hair. I love it. It's why I've been wearing my hair down more, because I love this thing so freaking much. Like, I love it so much. It is the hairdryer to end all hairdryers. It is the one. It is the one. This is the way. That's how I feel about that hairdryer. Like, this is the way. You never need anything else, my opinion, because I'm lazy and I want one tool to do the things. It is the way. Thank you, Susan, so much. Oh, Shannon, thank you so much, Creepshow. It's good to see you. It's good to see you. I love that you had a new video calling out fuckery on your channel. And fake, ridiculous text conversations. I love it when we call out the bullshit. Okay, we're going to get into all of the things. I love seeing you guys love the hairdryer too. Cherie says Ashley Paige just needs to start over with her own page. She didn't build the first one on her own anyway. That's exactly right. And that's what this motion pointed out, is how much money the company put into building that Instagram page. And the company's like, and this is how we built the page. And this is how we built this. And this is the money we put in with the marketing company. And this was our marketing strategy. They put a lot into it. And it really is interesting to see the company break that down. Now, again, in the Hayley Paige case, that is the company's perspective of what's happening, right? That's their allegations. But it was enough that the court was like, this is a reason to give it to you. And a lot of it lines up with how the page operates. And then if you have a company page, like, look, here's the thing. Has your boss, like the company you work for, ever had the password to your personal Instagram page? Because I'm going to say, if it's not work related, why does your boss have it? Jesse said, with regard to the Hayley Paige, that it sucks she can't use her own name even anymore, but she sold it and they trademarked it. She sold the rights to her name in relation to wedding dress design. And that's still going through court, but that's what the employment contract says. She sold the rights to her name and derivatives for dress design and wedding dress design. It doesn't mean she can't have a credit card in her name. It doesn't mean she can't make a hotel reservation in her name. It means that if she designs clothing or dresses in the future, it's going to be under another brand name. It's like Manny MUA using Lunar Beauty. If he ever sold Lunar Beauty and started like a Manny MUA beauty brand, then he can start that with his name. But you see people selling their name, the amount of money that she got is redacted out of it. But when you sell rights like that, it's generally for a substantial amount of money. But she sold the rights to her name. So, Kristen Neal, don't put Christmas prep on hold. Do it together. Do it together. Put in headphones. We can do it all at once. So it's not as if they took her name from her, but I'm sure it doesn't feel that way to her, just like it didn't feel that way to Prince when he wanted to go his separate ways with Sony. And Sony was like, but we own the rights to the name Prince, so you can go ahead and change your name to a symbol. And that's what happened when Prince lost the rights to his performing name. So I don't know what Kat Von D's deal was when she sold her makeup brand, but I would imagine she sold the rights to her name. And this is different than Kat Von D in that Kat built her brand and then sold it after. This brand was built under the JLM umbrella always. So they hired her as an employee, signed the rights to her name, and she built her brand underneath them versus selling it. But it would be like if Jeffree Star sold Jeffree Star Cosmetics today, he couldn't go start a second Jeffree Star Cosmetics. He would sell it with his name. I mean, or maybe they would just want the formulas at this point and wouldn't want his name. Who knew? Who knows? Maybe they'd be like, we don't want the name. We just want the lip scrub that like smells like root beer or popsicles or whatever. Like we want the products, not the name. But when you trademark your name, this is why we're going to be talking about the Ringo. When you trademark your name, when you have rights in your name and you sell those rights, though it feels shitty, the company's not wrong. And so it feels to me very much as going through the Hayley Paige stuff that she very much regrets the decision that she made, but it's a valid contract. She was paid for it. I don't know what you do with that. If you bought something from somebody like on Nextdoor or on Facebook Marketplace and you bought a washer dryer from someone and you're like, oh, thank you. Here's $200 for the washer dryer. Thank you for the washer dryer. And then like 2 years later, they came back and were like, yeah, so we sold that, but we'd really like it back now. Can you just give it back? No, we don't want to pay you for it. I just want you to give it back. You're going to be like, I'm sorry, I paid for that. And I've relied on that. And I haven't saved money to buy a new one. So you can go ahead and fuck right out of my driveway because I'm not giving you back what you sold me. That is exactly the company's perspective with the Hayley Paige stuff. Though I'm sure it sucks for her being like, oh, now I'm fully realizing the implications. Because I'm sure when she signed it, she didn't think that she would be on something like Say Yes to the Dress. She probably didn't know how much her personal brand would grow. JLM's going to argue that her personal bitch, I made you is what they're going to argue. Like I was going to try to couch that. And I'm like, no, they're going to argue, bitch, we made you. And she's going to say, but I'm the brand. So this is a very interesting breakdown of JLM can win this lawsuit based on what I've seen on the employment contract. Now, that doesn't mean her side's not going to come back and say that they breached the contract in some way. But based on what I've seen on the contract, JLM can win this. It doesn't mean they'll win in the court of public opinion. Because people might be like, you're being mean, evil company. We love Hayley Paige. So we'll see. They could win the lawsuit and still lose in the court of public opinion. However, if you're selling the rights to your name, here, we'll just pull it up real quick, and then we'll get into the Tati business partner lawsuit, because I'm just going to pull up the language that made this very clear to me. And then we will move on. The employment agreement is one of these redacted exhibits. All right. I hate the way exhibit is spelled, by the way. It's so confusing to me. Oh, this is the amended employment agreement. We don't need that one. We need the actual one. I know you guys know I'm a nerd because I love reading all these agreements. It's like when Kanye leaked his contracts, I was like, oh, music industry contracts, delicious. This is very much like a music industry contract. For me, it feels very similar. So we're going to go to as my computer struggles to keep up with me scrolling frantically. Come on. Termination, binding. No, we're going to go back a little bit to intellectual property rights. The header, hopefully you guys can see this. Let's make it big. The header says exclusive right to the designer name. So I know that she said I didn't have a lawyer read this, but y'all, it says exclusive right to the designer name. I don't know how we want to be more clear. And then it breaks down what that means. Grants the company the exclusive worldwide right to license to use her name, Hayley Paige Gutman, Hayley Gutman, Hayley Paige, or any derivative thereof. And it goes down in connection with the design, manufacture, marketing, and or sale of bridal clothing, bridal accessories, and related bridal and wedding items, including any and all goodwill associated. They've licensed her name to a jewelry line. And she knew that because she was part of those negotiations, but JLM licensed her name for the jewelry line, not her, because they have the right and they have the trademarks on it. And so we went into this in the other live stream on it. That's an agreement in perpetuity, meaning forever. They own the rights to the name because they've built equity in the brand. This is very much like an artist like Taylor Swift trying to get their masters back. They didn't sell Taylor back her masters. She was like, tell me, hundreds of millions, I'll throw the money at you. I don't think JLM will sell the rights back to Hayley Paige either. So, law lesson, not legal advice, life advice. If someone wants to buy the rights to your name, have conversations with more than one person, and probably conversations with someone in your industry, in the industry you're in, who has done something similar, and see how they feel about it. Businesses grow oftentimes with investment. JLM took on that investment. So they took on the investment to build it. So, all right, let me check Pacer. We're waiting, Pacer. Still not up. All right, let's get into Tati Westbrook's. Since we don't have our salty motion yet, TikTok, it's 6:30 on the West Coast. We are ready. All right, let's get into Tati Westbrook and Clark Swanson, because since we're talking about motions to dismiss this evening and we're still TikToking, I'm like, TikTok. We can talk about a different motion to dismiss. And I saw the Allie talking about the Call Her Daddy podcast. That's exactly what happened to the Call Her Daddy podcast. They tried it, but you can't. Look, agreements are agreements. And if you're signing contracts that are going to make you a lot of money, maybe have somebody walk you through the long-term implications. That's all. Have somebody walk you through those long-term implications. I missed some super chats. Sorry, y'all. Thank you so much, Dame. Thank you so much, Craft Happy Tammy. Thank you, Shonda. Trish Fox, at 25, did she have tangible success in design to cut a lucrative deal? Or do they do this with each designer to blanket possible successful designers? Trish, I don't know enough about JLM to know that. And I don't know enough about her career to know that. But the contract does say if we don't option to trademark it, then the agreement and the exclusive rights expire 2 years after the contract expires. So there were options in there, and then it grew. So we will see. Jennifer says multitasking now, making homemade mac and cheese sounds delicious for Christmas dinner tomorrow and watching with all the lawn nerds. We have a lot of lawn nerds up in here. We've got 4,767 lawn nerds, and I don't know how many likes are on this video, so you guys can tell me because I can't see. Angela said, can Trisha Paytas' second Insta account be closed down if it was started before her other account was shut down? I still think it can be. And we talked about the new terms of use on Instagram, but this is a standard term of use on Instagram that if you've been kicked off the platform, you cannot have another account on the platform. So I don't think it matters when she started it, because once she was removed, they have the right to remove all accounts from a particular user, not just a particular user account. Will they do that? I don't know. Can they do that under their terms of use? Yes, they can. Y'all, social media. I tell you, these platforms, YouTube, we love you. These platforms can do the things. They own the platform, which is why building in multiple places is definitely what it is. Oh, thank you, lawn nerds, for letting me know. 1.1, 1.2, 1.2. Thanks, everybody. So if you're on and you can go like. So let's get into the partner lawsuit. And for those of you on the replay, welcome to the partner lawsuit. While we're waiting on Pacer to update this motion that should be filed shortly, or should have been filed and should come through shortly. I saw the question in the chat, why wouldn't you have a lawyer read it? You wouldn't have a lawyer read it if you don't want to pay for a lawyer. That would be what it is. All right, let's get into this motion to dismiss from the Westbrooks in the Clark Swanson suit while we wait for Pacer to update with the response that's due today, because I didn't want to stream at 10 p.m. and I had upload issues earlier today, so we put that off. This is the motion to dismiss. Now, here's what's different. We're going to, let me pull up the other motion to dismiss. We're going to compare and contrast a little bit. So it's all of a sudden it is raining buckets outside. Buckets. I don't know if you guys can hear that, but it is raining buckets all of a sudden at my house, which is fun. Like, I love the weather. All right. Let us pull up the other motion to dismiss, because when we get that response, that's what we're talking about. What we're waiting on is the Tati Westbrook motion to dismiss response. The motion to dismiss was filed by KJ. In the partner lawsuit, the partner sued instead of Tati suing, and the motion to dismiss was filed by Tati Westbrook's attorney in that suit. The business partner suit and the defamation suit are two different lawsuits, different attorneys. So let me pull up different law firms. So let me pull up the defamation suit. And in the defamation suit, we have the defense motion to dismiss, which we will compare and contrast a little bit, because why not? Because you guys heard me talk about it and talk about what I thought of the motion to dismiss and all of the things. These are cases, one's in state court, one's in federal court, which is a difference, but both motions to dismiss. I will note the 45-line paper, which is a single space paper stylistically that pisses me off and I hate it, and there's no reason you would need it. So this is the motion to dismiss in the lawsuit, with the defamation lawsuit, as I call it. And now we're going to get into the motion to dismiss in the partner suit, which is in the Los Angeles Superior Court. This was just filed on 12/21. Gibson Dunn is the law firm for Tati Westbrook in the lawsuit with regard to Clark Swanson. They specially appearing defendant's notice of motion and motion to dismiss or stay the action for form nonconvenience. Notice the lovely 28-line paper. Sometimes it's a 26-line paper, but that nice space in there makes my eyes happy. I like it so much better. This is specially appearing because this is essentially a jurisdictional motion saying that this is not the right place. Los Angeles is not the right place for this lawsuit, which surprised me because the only contacts in the original lawsuit to Los Angeles was the assertion that Tati and James Westbrook still lived in Los Angeles, which we know that they don't. And there are declarations attached to this from Tati and James, and we'll pull those up too. So this is saying, hey, Your Honor, yeah, we like LA and everything, but it's like totally not the right place to have this lawsuit. So can we just boop that out to somewhere that actually makes sense for us? Cool, thanks, bye. And it's also saying we're not consenting to jurisdiction here. We are specially appearing just to tell you that you can't hear this case because it's the wrong form. Jay Taylor made a super chat saying, every time you say wait for it, I have an Aaron Burr moment. Every time I say wait for it, I hear that in my head. So I hear that in my head. Somebody said Gibson Dunn, Tati's not playing. No, when you're in LA and you're not playing, I mean, Gibson Dunn's a worldwide firm, but when you're not playing, Gibson Dunn is definitely the firm if you have the money to go to. There are other firms that are very good, but Gibson Dunn is a firm that has quite a long reputation. And here's the thing, they're for a firm that has the resources to deal with all of this. All right, let's jump in. This is going to be left open for the date to hear this at the Santa Monica courthouse. This is signed by Douglas. Is Douglas's last name Fuchs? Can we call him Douglas Fuchs? Y'all chat, let me know. Can we pronounce this last name Fuchs? Are we calling, do we have Saltsy and Fuchs? Are those the two attorneys representing Tati Westbrook? Please tell me I can call him Fuchs, that would be proper. I need you all to let me know. Can we do that? Can we do that? It's Saltsy and Fuchs, right? I think so. Okay. The fact that Douglas Fuchs is her attorney makes me super happy. Douglas, I don't know you. We are not making fun of your last name. The law nerds like to pet name the attorneys. This is now your pet name. Your pet name is Fuchs. So Fuchs gives a fuck about this being heard in Los Angeles and wants it to be in not Los Angeles. Thank you all. Yes, we're calling him Fuchs. Fuchs is German for fox. What does the fuck say? No, we're God, if Salty and Fuchs had a firm, no, Fuchs should be his nickname. The Salty Fuchs firm. We're gonna keep with the facts. Facts, not fucksery. All right, I'm dead. This is very exciting to me. Tati, I'm sure you don't watch these videos literally ever, and that's fine. But if you do, your choice in attorneys has given us absolute glee. Thank you so much for letting us have a giggle. That is just harmless fun. All right, Mr. Fuchs, let's see what we got here. Thank you for the table of contents. It's pleasing to the eye. It makes it so easy to get through. I appreciate it. This stylistically makes my nerd heart happy. So let's go. Let's go. Ah, a table of authority. Look, Your Honor, this is the law that I'm relying on. Just in case you want to know what law I'm relying on, this is the case law. Here are the statutes, Your Honor, and here are a few other authorities that we're relying on. Thank you, Mr. Fuchs. We appreciate you. And we know we've got some of the Cal, and then we've got some of the Nevada. We've got both. We've got both. Look, there's a chart. Saltsy, I love you, but Fuchs is also winning my heart. Like, Fuchs is not fucking around. There's a chart. I appreciate a chart. I appreciate the chart. Hooker and Habib is a real offer. My mom's firm worked with them. Sometimes your last name is your last name. I'm feeling, Shelby, that Tati gives a lot of fucks, and the name of attorneys makes me happy. Look at this lovely chart. Convenience, fairness, and common sense. This feels like it's written from Legally Blonde, right? Passenger shaming. I love you, girl. I'm a salty fuck 90% of the time. Me too. Me too. We are. All right. Convenience, fairness, and common sense dictate that this case should be litigated in Nevada, not California. There we go. We know off the bat what we're asking for. We get right into it. Your Honor, this shouldn't be in California. The plaintiffs in this case are both Nevada residents. They seek to bring claims derivatively on behalf of two Nevada business entities, because the Halo business entities we're talking about are Nevada companies, against the directors and officers of those companies pursuant to Nevada corporate law. Well, California, you know what California doesn't want to enforce? Nevada law. Nevada, we're trying. Nevada, I think it's a long sorry, Nevada, Nevadans, Las Vegas friends. I know there's other parts of Nevada, but yes, anyway. With the exception of a single defunct corporation that has no assets and no interest in this suit, not a single one of the parties resides in California. Not one. As illustrated in the chart below, all of the parties with any interest in this action are domiciled either in Nevada or Washington State. Clark Swanson lives in Nevada. Swanson Global Enterprises is also in Nevada. Tati and James Westbrook live in Washington. Halo Beauty Partners is in Nevada. Halo Beauty Inc. is in Nevada. Halo Beauty Inc. 2017 is in California, and then it moved to Nevada. Tati Cosmetics. So this Halo Beauty Inc. is now this Halo Beauty Partners from what the last lawsuit indicated, from what this lawsuit indicated. When I was looking at the corporations, it looked like they made the decision to move this company into Nevada for tax purposes. Nevada. Nevada. Tati Cosmetics Inc. is a Washington company. Tati Halo Inc. is a Washington company. So what they're saying is the plaintiffs can sue where they choose. But the plaintiffs are suing on behalf of the company. That's what the derivative suit means. Nevada. I will always forget Nevada. I always think it's Nevada, and then I second guess myself. Anyway, the derivative suit here is because Clark is also suing on behalf of Halo, saying, hey, you're also fucking with the company. And so as a owner and interest in the company is also suing you. So the company's also suing you, but the company is also in Nevada. So that's what that means by derivative. So, thank you, Tracy. That's what that means. Whereas all of the critical parties in this dispute are either residents of Nevada or Washington, the only party with a connection to California is Halo Beauty Inc., a California corporation, but that corporation is an empty shell company whose assets, including the legal claims the plaintiffs purported to assert here, were transferred to Halo Beauty Inc. So that's the transfer to, not to Halo Beauty Partners, to Halo Beauty Inc. And then you guys look at the footnotes. There's footnotes explaining the corporate entities. Swanson's complaint falsely asserts that Tatiana Westbrook and James Westbrook, collectively the Westbrooks, reside and are domiciled in California, as explained infra at page 6. This is incorrect. Halo Beauty Partners LLC is the primary entity at issue in this litigation. It owns and operates a nutraceuticals manufacturing, marketing, and distribution business. Clark Swanson, James Westbrook, and Tati Westbrook each own 33%. Halo Beauty Inc. is a Nevada corporation, owns and licenses certain intellectual property. Halo Beauty Inc. owns 1% stake interest in Halo Beauty Partners. Okay. So this gets into why. Now, we're not trying to spill tea. Notice we're not telling a story. We're getting into who the companies are, why the companies are, and where they all reside. That's all that they're doing in this. That's it. That's it. Look, everyone is either in Nevada or in Washington. Passenger shaming, you're so sweet. Thank you. Nevada is not only a suitable forum for this dispute, but it is also by far the most appropriate forum to litigate this dispute. First, Nevada is the most convenient location for most of the affected individuals. as the employees of Halo Beauty, who will be called as witnesses, including plaintiff Swanson, reside there. Second, any corporate records not in electronic form and not in the possession of the Westbrooks are located there, which means why do we have to ship all of this shit to California to go to trial when it's already in a state where you could sue, but you didn't? I have thoughts about why they didn't. We'll get to those. Like, as I'm reading this, I'm like, oh, I see. I see why they don't want it in Nevada. We'll get there. Third, there is public interest and sense of fairness in having Nevada court evaluate derivative claims governed by Nevada law brought by a Nevada citizen purportedly on behalf of Nevada companies. Fourth, common sense dictates that a Nevada court is best suited to analyze and apply the complexities of Nevada law. Well, you don't say. You don't say that the courts in the state would want to litigate on behalf of the state. And then by contrast, California has no interest in adjudicating this dispute concerning the governance of Nevada business entities by Nevada and Washington citizens. That's true. I think in the underlying lawsuit that the reason he stated, and let's pull it up, Clark Swanson stated that they both that the Westbrooks lived in Los Angeles, but we know, why do we know he knew? It was discussed that he knew that they had moved, but I don't remember where I know that from. But it might have been in the response letter to them that I had a video about, and I'll have to go back and dig it up as I talk about this more, because they moved in 2018, so it was not unknown to him that they had moved. And I'm sure they will be able to prove it. We're also going to have exhibits attached to this, so we're going to look at the exhibits. But now I want to pull up the lawsuit in a separate window so I don't have to flip back and forth. Let's pull up this defamation suit, because I wanted to pull up oh no, that's the defamation one. We're not there yet. We're still waiting. Defamation suit. We need the partner suit, and we need the complaint. There we go. All right. When it talks about jurisdiction and venue, let's just see what they said so we can all evaluate this together. When it talks about jurisdiction and venue here, jurisdiction and venue, this court may exercise. Now, this is Clark Swanson's filing talking about it. Here, let's actually do this the right way, because I've learned it's better. This court may exercise jurisdiction to hear this matter because from the time of the events in the complaint to present, the individual defendants, Tati Westbrook and James Westbrook, reside in Los Angeles. They are also identified as the corporate officers and directors of Halo with the business address, but they don't live there. Furthermore, the court may exercise jurisdiction to hear this matter because agreements at issue in the lawsuit were entered into in Los Angeles County. I don't think that's going to be enough. And breached in meetings that occurred in Los Angeles. I don't think that's going to be enough. Furthermore, this court may exercise jurisdiction over the lawsuit because Halo Beauty Inc. is and has been from August 15th, 2017, a California corporation in good standing. I don't know if that's going to be enough when there's so much else, but you have one entity there, but that's not the entity that's suing. And then the court may exercise jurisdiction over Tati because it's member managed. And the member manager of Halo Beauty, who does business in Los Angeles, continue to suffer and sufficient to confer jurisdiction. I don't think that blanket statement's enough, because that all turns on the assumption that Tati lives in California, which they're saying that they don't. So, okay, do we see the difference in the introduction? This just went into, hey, Your Honor, this is why this has to be here. This went into, hey, Your Honor, this is who the parties are, but we don't really know why we're here yet. Just saying. Just a juxtapose. So now we get into the closing sentence. The closing sentence of this is, for these reasons, defendant respectfully requests that the court dismiss or stay this action for form nonconvenience. Now we know, in a half a page, page and a half. In a page and a half, we know why we're here, what the law is, and what is being asked for. So that's what it is. Now, if this moves to Nevada, Gibson Dunn, I don't know if they have a location there, but the Gibson Dunn attorneys will probably just wave in and have local counsel as well, the same way that Salty is doing in Washington. They have Washington location, and then they have Washington counsel, and then they have Salty and his firm. Background. So this gets into, the fact that Swanson lives in Nevada, that the Westbrooks are in Washington State, and then the derivative defendant Halo Beauty is a Nevada corporation. And the reason I scrolled through that is because I don't want there to be addresses on there, and it looked like there might have been, and I haven't redacted this yet because it's a first look. And even though it's a corporate file or it's a public filing, I don't want to put that up. So if that is in there, I will go blur it out when I go back over this. In late 2018, Swanson and the Westbrooks decided to move Halo Beauty from California to Nevada for tax purposes. Wise. I understand that. I have a lot of companies that do that, but it works best if you don't also live there, and it works better for big companies, but that's a whole other thing. It's a conversation worth having as companies grow. The factual background gets into the case. We will go over that in a deep dive, but it just gets into their factual recitation of the case. It gets into the complaint. Swanson's complaint includes 15 causes of action with a confusing array of overlapping claims, but the crux of Swanson's lawsuit is that the Westbrooks orally promised to make Halo Beauty Miss Westbrook's exclusive channel for all things beauty, and that is the crux of the case. And you know why that's the crux of the case? This is why it's in California. This has to be why it's in California. Okay, Emily speculation. Here we go. We're scrolling to the end. The crux of the case being that oral promise, so that verbal promise, not a written promise, not a promise sealed over oral either, or not a written agreement, not in an email, not in a text, but a spoken promise. That is what is being alleged as the crux of this. And really, that is what the crux, I think that accurately states this case. Let's look at Swanson's main causes of action then. We've got all the negligence and the breach. Those are all based on that agreement. Gross negligence, fraudulent misrepresentation, that's that verbal promise. Breach of contract, verbal promise. Breach of good faith and fair dealing, not a verbal contract, but it's kind of the crux of the thing. This promissory estoppel claim based on an oral agreement is a old common law theory that not every state will enforce. And I bet you that Nevada does not have a cause of action for promissory estoppel. I bet you that they don't. And I bet that's why California was chosen. Because if you don't have the promissory estoppel, if Nevada does not honor oral agreements, it's always so weird to say oral. I mean, maybe I'm a child. If Nevada does not honor spoken agreements, and that is the basis of the case, then it's going to be much harder to get past a motion to dismiss in Nevada than it's going to be to get past it in California. Because in California, it's like, well, you have a cause of action there and we can hear it. But in Nevada, it's like, there's no cause of action for that. There's no cause of action for verbal agreements. So if you don't have that promissory estoppel claim over the breach of a verbal agreement, then you don't have a case. Rich Lux, always get it in writing, Judge Judy told me. Judge Judy would be correct. I mean, that writing can be an email, a text message, but just because people say shit doesn't mean that's what they mean. And I appreciate the support. Thanks, Rich Lux. So I think that the reason this was tangentially filed in Los Angeles was to enforce that verbal contract. But when the court says this is not the right form, which they very well may, then we've got a whole different case where Swanson is going to have to find a breach of the written contracts by Tati and James, which is not originally what was filed in this. And I just think we have oral in Nevada and a lawyer named Futz. Yep, that's what we got, Little Red. You guys, I bet you that's why this wasn't filed there, because verbal agreements cannot be enforced in Nevada. Oh, that's going to be interesting. So here's what happens. If this motion is granted and the case is removed to Nevada, then Clark has to choose to either try to go forward on breach of contract claims, but then you have to prove what the contract says. And if the main breach of the contract is this change to the 33%, and that the reason you changed from 50 to 33% was because of this promise, but it's not a written promise, then you can't enforce that. And then there's really no breach unless there are other breaches that weren't alleged. But if you're suing, you allege all the things because you like, this is all this shit that you did. Let's just solve it all. Classy Mom says, according to my contracts law professor, a contract can be formed on a napkin. It can be because it's written. So verbal agreements are different, but I bet you that's why. Hold on. Let me just. I will pull law on this, but it will be interesting to see if you have those kind of promissory estoppel claims, and if you can enforce that in Nevada. So I need to go look at Nevada's statutes on this, but I wonder if that is kind of the heart of this. So we will see. Let's go back. Wait, no. Let's check Pacer again. Let's see. Okay, people, it's almost 9 p.m. Let's check Pacer. Why am I getting text messages? I'm getting texts from friends. Not yet. I wonder if it'll be up. We'll see. We're going to keep going over this, and if it's not up, then we might have to talk tomorrow. I wasn't going to talk tomorrow. Maybe I'll film it and drop it if it goes up after this. I can't imagine what time their filing deadline is because it's almost 9 o'clock. So, Hey, Jen Love, I didn't see you come in, but I saw Rich's comment. So hello, everybody. It's so good to see you. Okay. Nevada has promissory estoppel if the party asserting estoppels relied on the conduct of the other party to his detriment. Mama Potter Sims, thank you very much. It's definitely something I'm going to look at. It's going to be interesting if there was a tactical reason to choose California and it gets moved from California, how it's going to be perceived. And so Callie Cat asked, how can you validate verbal statements enough for a court case? Can't they be falsified? Well, ideally, one wouldn't lie when they are in a signed declaration, but you would also rely on other actions. So what we're seeing in the Tati Westbrook business partner case is that Clark is saying, hey, I had 50% of the company. Now I have 33% of the company. I did that because they promised this. And Tati and James Westbrook are saying, no, we did this because of this other thing. And the reason that the change was made is because of this. And if you look at the writing, it never materializes it. So in the writing of the agreement, that conversation they had where they changed the ownership, Tati and James take on that from what they've filed and what they provided to, well, their attorneys provided to me in the declared, like, Tati Speaks that I have the video on. I'll link it. But in that document, it was, no, we took less of an investment from you and we reduced your role in the company. Therefore, we reduced your ownership in the company. So there is an explanation there. And also, we never saw it in writing, but we did see that Clark memorialized the change and said, hey, we're changing it from 50 to 33, but never said because of this. So it's going to be this is a hard case anyway, the business partner lawsuit. And when it was first written, it was like, ooh, T. And then when you jump down into it, you're like, oh, wait a second. Why don't we pull the Articles of Incorporation Association? Vice versa, because this was an amendment afterwards and we pulled them in another video. So that's why we pulled them in another video, and I will pull them again if we need to, but it's not memorialized there. So they do all own 33. He says it was changed for nefarious reasons. They say that it wasn't. Either way, they're saying it belongs in Nevada. And then they're getting into, look what they're getting into, you guys. It's the legal standard. Oh, IRAC format. Look. Issue. Here's the issue. This should be in Nevada. Here's what I want you to do. Defendants respectfully request the court dismiss or stay this action for form nonconvenience. And then here's the reason. Okay. Now here's the rule. Issue, rule. Here's the legal standard. And then we're going to get analysis. Down here, we're going to get analysis and conclusion. Analysis. And then we're going to get a conclusion. Look at that. Mr. Fuchs, we appreciate you. All right. Let's get into the law a little bit and then get into the argument. The legal standard for form nonconvenience doctrine is codified in CCP 410.30, which states, in the interest of substantial justice, an action should be heard in a form outside this state. The court shall stay or dismiss this action in whole or in part on any conditions that may be just. The doctrine of form nonconvenience is rooted in equity, meaning like, hey, everything's in this other state. Can you please not make us come back here? Please. The doctrine of form nonconvenience is rooted in equity. It allows the court to decline or exercise its jurisdiction over a case when it determines that case to be more appropriately and justly tried elsewhere, as the moving party defendants bear the burden of proof on the issue of equity, entitlement to a dismissal. That means Tati's side has to say why it should be dismissed. And then we're going to get into the argument. Nevada's suitable form for the plaintiff's claims because Nevada has most of the parties in it. The defendant can be subject to jurisdiction of the courts in alternative form. The statute of limitation does not bar the claims. So, hey, the Nevada statute won't mean you can't bring it, blah, blah, blah. That the Westbrooks purposely availed themselves of the privilege of conducting activities in Nevada in connection with those Nevada entities, meaning they know that they could have jurisdiction there because that's where their business is. Then it gets into the test of the private and public interest. And then it's going to argue why it should be. So this is the why it should be. Feminist Heathen says the bar for relief is much higher in Nevada on a promissory estoppel case than California. That's a wonderful thing to know. And I imagine that's why there was a strategic decision to try to move this into California. But here we are. So here we are. They are then going to weigh the factors out in the way that they see fit. Of course, there will be an opportunity for a reply to this from Clark's side saying, no, that's not how this weighs out. No, that's not what the law says. But it says Nevada has a compelling interest. I did it wrong. Nevada has a compelling interest. The majority of plaintiffs' claims are derivative claims by Nevada entities against their directors. That's true. I agree with that statement. Under the internal affairs doctrine, which both California and Nevada have adopted, these derivative claims are governed by the law of the state of incorporation, which is Nevada. So, in fact, the state of Nevada created specialized Nevada business courts. Who knew? Specifically to address these types of business-related lawsuits, including shareholder derivative actions. Do y'all remember in the videos when I said shareholder derivative actions are really like heady and thick and steep and there's a lot that goes into them, and it is more than just dealing with a regular breach of contract because it's a derivative suit? Because Nevada is such a regular form for businesses, because Nevada is like, hey, boo, we know that you don't love California other than like the weather and the palm trees. So you can go ahead and just house your businesses here, and we're not going to like tax the ever loving fuck out of you. So we are actually going to be so business friendly that we're going to have our own courts with judges who regularly practice in nothing but derivative suits and these kinds of business litigation, so that you can resolve your business disputes without getting stuck behind everything the fuck else, so that we can streamline your case, as opposed to clogging up California, which is so backed up that you're not even going to get a court date until sometime in 2022. And if you believe what's on Overheard Courthouse's Instagram account, you had litigants being offered to duel in the street by the judge. And the judge was like, I can't give you a senior court date. Would you like me to have you duel in the street? Like, there's nothing I can do. The courts are so backed up in California, particularly in Los Angeles County. So Nevada's got its own little courty courts. If I was a judge reading this, I'd be like, bye. You can go to, the chart would have probably done it for me. You can go to Nevada now. We don't need you here. See you. See you, see you, see you later. Pink Piggy, that is up for debate. I think when she said all-encompassing brand, it's being interpreted differently by the different parties. I think it can be interpreted either way. So we'll see. But yes, I think that there is reason to believe that in both places. Is that enough? Is a comment in a YouTube video enough to make it so within the corporation? I don't know, but that's what they are relying on. So Nevada's got its own specialized courty courts. The goal of Nevada's business courts include, among other things, promoting business in the state. Hey, I just said that. By improving the justice system, offering speedier and cost-effective resolutions, and providing business entities with legal predictability. Well, isn't that... Thanks, Nevada. That's really cool. No wonder everybody's like, can we just do business there? Can we just do business there? Lou said, isn't there supposed to be a KJ filing tonight? There is supposed to be a KJ filing tonight, but I don't know if the federal court gives him till midnight, West Coast. It could be a 9 p.m. deadline. It could be a day deadline with a 12 p.m. I was hoping when I set this for 8 p.m. that it would be filed by end of business day. But we will see. If not, I was not going to stream tomorrow at all because it is Christmas Eve, but we will figure it out. I was really hoping it would be up. I'll check it again. Once we go through this, I want to pull up the declarations and then we'll check it again. We've already been talking for like an hour. So somebody said, and it might be a full business day. I'm hoping. Can you text Salty and ask? No, Rachel, I can't. We're just hoping. So let's get back to the business partner suit. I'll answer some questions and we'll check again. Welcome to the channel. And then we'll go from there. And if we have to talk about it later, we'll talk about it later. Everyone tweet at Salty. Like, we're impatient, Salty. It's late. I know it's not that late on the West Coast. It's what, 6 o'clock there? 7 o'clock there. It's not that late for them. It's still not on Pacer. Yep. No, I set this on assumptions knowing that this would be here. Tati won this lawsuit hands down, in my opinion. Rich, I think the business partner suit is going to be a lot harder. I think it's going to be a hard suit for Clark. I really do. Derivative actions are tough. If it gets moved to Nevada, there was a strategic reason to put this in California. What that strategic reason is, we can guess at, but obviously we don't know. I don't know. Not the lawyer involved in this suit. Just like to talk about this shit on the YouTubes. But if the strategic reason was that business courts and that these specialized business courts are going to be stricter than courts in California or judges who don't do this all the time, then we will see. We will just see if that was the reason. Because what can happen is if the court grants this motion, they can then choose to refile it in Nevada. They can choose to try to settle it again. Oh my God, it's raining so hard. So they can choose to try to settle it again. And that might be the thing. So this motion could get granted, and then we could see this suit just piecing out, and then they settle it. We'll see. Jake's Baby Cake said poor Salty is on vacation in Hawaii and he has to file this. Well, he knew that this was coming. So anyway, he knew that this was coming. Everybody's like, hurry up, Salty. Yes, we want to talk about the things, but we'll finish talking about this thing because there are declarations that we'll pull up. So they went through the rest of the case law and the fact that the California doesn't have an interest in the case because it's really Nevada people filing this suit against or on behalf of a Nevada company. And the only other people are residents of Washington. I mean, the chart is tremendously helpful. Again, hey, that's not what I wanted to have happen. I used to use Wave and I don't anymore, and I hit something wrong, clearly. Bring me back to my lawsuits in my drive. Where did it go? Where's my motion to dismiss? All right. And then we'll pull up the declarations. Sharon says, my source of deadline, U.S. District Court, Western District of Washington, electronic filing for civil and criminal cases, 1/17/2020. That they probably do have to file by midnight. I was hoping by end of day. We'll see. Either way, it's going to have to be Washington time, not Hawaii time. All right, let's pull this back up. I doubt Salty's watching. He's got a motion to finish or to file or to deal with the filing or to make sure everything's there. I doubt that he's watching. I absolutely believe that they are probably finishing up this motion. We'll go check Pacer again in a second. Let's get back to let's just scroll through how much we love a table of contents and a table of authorities and the amount of money that this probably cost to have written by Gibson Dunn and this lovely little chart of where everybody lives and this company that is just a holding company that's not an operating entity and that all the employees are there. So, Nevada's statute of limitation for taking, hold on, I can't see because I'm on the wrong side. For taking a breach of contract for an oral agreement to the court is 4 years, no contract, no F's given. And I will go back and find the date of this. I don't know if 4 years is going to be an issue. We will pull it up. We will go pull it up. All right. So we've gotten to the legal standard. Let me try to make this bigger. I need a second monitor for all of this. Where were we? All right. We are down at the end about California not having interest in adjudicating using Nevada law. Because again, you do need to use Nevada law. And so they're saying Nevada should probably do that. Nevada is the proper form for this dispute. Plaintiffs are Nevada residents. Companies on whose behalf they seek to bring the claims are organized in Nevada and governed by Nevada law. There's no legitimate connection between this matter and the state of California. Plaintiffs' attempt to bring this suit in California is inconvenient for the affected individuals and inconsistent with public interest. For the reasons set herein, the court should dismiss or stay this action for form nonconvenience. So really just a straight ass breakdown. This is what I like to see. Look, this is what I like to see in a conclusion. Hold on. We're going to juxtapose conclusions. Let's go to the conclusion in the defamation motion to dismiss, since we're comparing motions to dismiss and contrasting and being shady just a little bit. Where's the conclusion? The defects in plaintiff's complaint are numerous, clear, and fatal. The court should dismiss this action. Why? Where's all the rest of the stuff? We want the rest of the stuff. We want the rest of the stuff. The rest of the stuff is not here on this one. All right, let's pull up the declarations that were filed with this. Oh my goodness, there are 5,000 law nerds in here. Hi, law nerds. We're all waiting for Pacer to update because Salty's motion isn't filed yet. And so we're chatting. What does juxtapose mean? I'm comparing and contrasting the two. We're looking at the two things together because we've got two. It is good to see. I hope everybody's doing other stuff while we're just rambling on about law nerd shit. Okay, let's pull up some declarations. We love a declaration. Let's see what's in these declarations. The motion to dismiss in the defamation suit also had declarations attached. Remember, we all had questions about those. So let's see. Also, the pineapple booch is really, really good. I'm kind of living for it. I'm glad I bought more than one because it's delicious. All right. Declaration. This is the wrong case, Emily. This is the defamation suit. We need the business partner suit. This is what happens. I have so many lawsuits stored right now, especially with all the Erica Girardi stuff, because y'all, so many lawsuits. Where is the meet and confer? We've talked about a meet and confer. This meet and confer said, hey, we're filing the motion and we met and conferred and we still need to file the motion. Remember, the meet and confer wasn't in the other one. Yeah. The meet and confer was in this one, which is nice. That was filed. Like, hey, you want us to do the things, we did the things, and we had the meet and confer. We also have declarations. Here's Tati's declaration. Oh, Linda, thank you so much. Merry Christmas from Tasmania, Australia. Thank you. Passenger shaming. I'm picturing Emily like a girl on one of those CSI shows. We need 15 desktop monitors. We do. And 1 to 2 on the wall. We do. And some Law and Order da-dung noises. I know. I need my own noise. I've got the music for the podcast, but we definitely need some noises. It's fun. Thank you very much. All right, let's pull up Tati's declaration, see what it says. Oh, wait, let me look at it and make sure it doesn't have like, I live in Washington and this is my home address. Oh, it sure does. Damn it. All right, I'm going to read it. I'm not going to put it on the screen because I haven't blacked it out, and I will do that. Emily, when she's saying where she lives, this is going to come up in these lawsuits, but you guys, let's not dox Tati. Let's not do that with these lawsuits. Tati Westbrook, I declare as follows, unless otherwise stated. It must have been an interesting thing to know that these are public, to know that people are talking about them, to know that they're on Pacer, and to know that you're going to need to share where you live. It's going to be difficult. So I would imagine that that's like I really don't want to. All right. I'm just going to read it. So I, Tatiana Westbrook, declare as follows, unless otherwise stated, I have personal knowledge of the matters stated below, and if called upon to do so, I could and would competently testify to those facts. I made the decision to become a resident of the state of Washington in December 2018 and signed a long-term lease for my condominium. My address in Washington. I grew up in Seattle, Washington. My mother, father, stepfather, grandmother, sister, and sister's extended family all live in Washington. My personal bank accounts are in Washington. I own investment property in Washington. My business and their bank accounts, including Tati Inc. and Tati Halo Inc. and Tati Cosmetics, are all incorporated in Washington. I do not own or rent any property in California. I declare under penalty of perjury, signed the December date in Bellevue, Washington. So that is the motion there. There's one from, or that's the declaration there. There's one from James Westbrook, I believe. And it is similarly situated. So I'm not going to pull it up on the screen until I can black that out just for my own purposes and redact that. But I will read it. Unless otherwise stated, this is James Westbrook. I have personal knowledge of the matters stated below, and if called upon to do so, I could and would competently testify to those facts. I made the decision to become a resident of the state of Washington in December 2018 and signed a long-term lease for my condominium. My address is in Washington. I received a driver's license from Washington on January 2nd, 2019. My personal bank accounts are all located in Washington. I own investment property in Washington. Same stuff about the Tati that's in the other one. In December 2016, Clark Swanson, Tati Westbrook, and I decided to create a nutraceutical company. The company was eventually called Halo Beauty. Mr. Swanson was initially responsible for, among other things, developing the nutraceutical supplement. Oh, I can pull this up because I can get past the address on this. Okay. Let's talk. There's T in this one. Tati's like, I just live here. And James is like, I have it. The company was eventually called Halo Beauty. Mr. Swanson was initially responsible for, among other things, developing the nutritional supplement formulas and handling the company finances. I was tasked with overseeing Mr. Swanson's developmental process. Miss Westbrook, one of the top beauty influencers in the world, was responsible for branding and marketing the product directly to consumers through her YouTube channel with millions of subscribers. Yes, we know. It was originally anticipated that Mr. Swanson would provide half of the necessary capital to build the business and oversee day-to-day operations. As a result of his anticipated capital contribution, the money that went into the business, the investment, and the anticipated amount of work he was supposed to do, the parties agreed that Mr. Swanson would receive 50% equity. Ms. Westbrook and I would each receive 25% equity in Halo Beauty. But during the first 7 months of 2017, Swanson was unreliable and unproductive. Swanson's repeated failures to perform his responsibilities, combined with Mr. Swanson's own flailing financial situation, led to a restructuring of the organization. On August 1st, 2017, Swanson, Tati, and I'm filling those in, so it's okay to read. Swanson, Westbrook, and Tati and I would become agreed that I would become the chief operating officer and take over the company's business and day-to-day business development and day-to-day operations. And Tati, whose YouTube stardom made her the most irreplaceable partner, would serve as president and chief executive officer. The parties also agreed to be equal members such that each of us held 33.33% equity in Halo in consideration for restructuring the equity. Mr. Swanson was relieved of his responsibilities for running of the day-to-day operations and partially relieved of his upcoming capital money obligations, which saved him over $100,000. So that's the argument that this is the consideration. That's the argument that we restructured this, and what you got for the restructure was not this promise that it was going to be Tati's exclusive vehicle, but the promise that the situation that A, you would have less opportunity, and B, it would be $100,000 less in cash. So Morgan, yes, people can get the lawsuits. They generally have to pay for them. I'm not putting people's addresses up on my channel because I don't want to. So let me go ahead and check. All right. Halo Beauty Inc. was originally incorporated in California. Oh, I didn't pull it back up. Sorry, y'all. Was originally incorporated in California in late 2018. Mr. Swanson, Tati, and I decided to move Halo Beauty from California to Nevada for tax purposes. On or around May 23rd, 2019, underwent an F reorganization, which moved it. It talks about the ownership of the Nevada Corporation. Nevada is a more convenient location for litigation of this case than California for me personally and for the employees of Halo. Halo has 2 full-time employees, both whom reside in Nevada and have relevant knowledge regarding Swanson's claims. Most of the other potential witnesses, such as manufacturers and other business partners, reside outside of California. I am not aware of any relevant hard copy documents that exist in California. The relevant documents are maintained electronically or in Nevada or Washington. I declare under penalty of perjury, signature. So this is answering it, and this is giving a little bit more context to it and doing it in a signed declaration. So I'm going to go check Pacer again, and then it's 9:24. I'm going to try to pronounce that Kitty Row Lil. I'm going to slaughter that. I'm sorry. Kitty Arlil. I'm not going to get it right. I apologize. I just am not going to get it right. I'm loving that you geek out over this motion compared to the abject confusion over KJ's motion. They were filed in the right order. They were. So we got to look at the two together. Cindy, thank you so much. Let me see if there's any questions as we're getting through this. And then let me go see if there's any other declarations. I think there's one from the attorney. Jennifer, I was told to add bacon to add to the mac and cheese because we just butchered one of our pigs from our farm. That sounds delicious and delicious. I like bacon. Sleeved Christy, are they asking for a dismissal? In the business partner lawsuit, because we're still waiting on Salty's motion, but in the business partner lawsuit, they are asking for it to be dismissed or stayed so it can be filed in a more appropriate venue, which is similar to what KJ's team, I think, was trying to ask for. So, Steph, you're so amazing. You make law easy to understand. Thank you so much. Thank you. I appreciate it. All right. Let me see if there's any other declarations here, and then we'll check Pacer again, and then we'll go from there. And again, if we have to do this another time, then we have to do this another time. Purple Giraffe said, what are the laws for audio recording? Do both parties need to know it's being recorded or just one person? Purple Giraffe, that is not on topic at all. And it also very much varies by jurisdiction. So I would look where you live because it varies by jurisdiction and by country. So sometimes it just depends. All right, let's see if there is another declaration, because I think there was one. Let me make sure we didn't miss anything in this. I think the declaration from the lawyer that I'm thinking of was just the meet and confer, that they've got the stipulated pleading schedule and the jury trial demand and the original lawsuit. So no, that's it. And there's still nothing on Pacer, which means it's probably going to be filed closer to midnight on the West Coast, which is going to be way too late for our purposes. I was hoping, I knew it was a gamble. Truth Sleuth was like, I haven't seen anything. And I'm like, I'm hoping it's filed by end of business day. I'm hoping. So, Jay Chantel said, does Washington allow verbal contracts? Would it be worth it for them to move it from California to Washington? No, because I think they would argue the same thing with the form nonconvenience in Washington based on, let me pull that chart back up and talk about form. So form has to go to all of the things. Passenger shaming is like, we appreciate the gamble. I do too. I was like, look, tomorrow's Christmas Eve. It's due today. It's going to be up. Maybe it'll be up end of day. We'll see. It could still go up while we're still here. So this chart talks about where everybody lives. So here's the thing with form. They break down the law really well on this, and it's not that I'm inclined one way or the other in the Tati suit with the business partner. I think there are some difficult concepts to overcome because it's not in a contract. And we've talked about that in other suits where I'm like, well, the contract says this. So we've got multiple parties in Nevada suing with regard to Nevada companies on behalf of Nevada companies. So let me pull up the business partner lawsuit. Here's the suit. So it's Clark Swanson himself who lives in Nevada on behalf, so derivatively on behalf of Halo Beauty Inc., a California corporation. But what the motion is saying is that Halo Beauty Inc. is the holding company, not the operating company. So Halo Beauty Inc. is the holding company, not the operating company. And that this Halo Beauty Inc. is the operating company, the company that organizes the day-to-day business. And that's not uncommon, but that means that Halo Beauty Inc., the California company, is irrelevant because it's not the operating company. Swanson Global Enterprises Inc., which is a Nevada company, which they don't say. Look, it says on behalf of Halo Beauty Inc., a California corporation, and Swanson Global Enterprises Inc. on its own behalf and derivatively, but it doesn't say where it's located, which is interesting. It could just be an oversight. And on behalf of Halo Beauty Partners LLC, a Nevada limited liability company. But this passes through, this Halo Beauty Inc. passes through to this Halo Beauty Inc., the Nevada one, because they did that F reorganization, which was in James Westbrook's declaration. So even if they filed in Washington, the most of the action is in Nevada. And even if they follow in Washington, they could still bring the same form nonconvenience saying, yes, now we're in Washington, and yes, it's where the Westbrooks live, but this is a derivative suit with regard to a Nevada corporation, which means Nevada law applies, which means it needs to be in Nevada. So they could still bring another derivative suit. I think what might happen here, we'll see what the court rules. There's going to be a response to this motion to dismiss, and we'll see how the court rules. And if the court rules in favor, what can happen on the motion to dismiss is that they dismiss it and refile it in Nevada, or they dismiss it and say, okay, so that didn't work. Maybe we should just resolve this. How can we resolve it? Jennifer asked, will Tati's lawyers get more respect than Swanson's because their filing was so concise and to the point while his threw shade? I don't know about that because the initial complaint, even though it definitely had its shade, the initial complaint did still follow the basic parameters, other than the fact that the attorney didn't sign it. But the initial complaint for Swanson's did follow the parameters. They gave the summary of the lawsuit, the jurisdiction and venue, even though Tati's side is saying, well, we don't believe or agree with some of those assertions, that, you get into who the parties are. And yeah, they took some digs at Tati, but complaints have a bit of advocacy in them, a bit of argument in them anyway. And it's formatted properly. It is pretty clear to read. Like, you understand the dispute here for sure. You understand what's going on. It's just that they are not agreeing on how these facts go. And so I don't think the court might disagree with the jurisdiction in this, but I don't think the court's going to look at this complaint and just be like, ugh, whatever. The only thing that raises an eyebrow to me, some of the language is what it is, but it doesn't offend the way other things I've seen. I'm just like, come on, this is irrelevant. Stuff in here is relevant to the argument they're making because they're making that promissory estoppel argument, but the lawyer doesn't sign it, which is curious to me. Like, the lawyers didn't sign it. Like, Mr. Smith didn't sign it when it was digitally filed, which is curious to me. Swanson verified it and signed it. And if the court sees the declaration that Tati and James don't live there, and Swanson signed this under penalty of perjury and declared, we're scrolling. He declared that the Westbrooks live in California. And so a court might just be like, but you're declaring here that they live in California. And you're saying that you know that they live in California, but they don't. So it's not on information and belief. He's saying they live in California. So let's look, and then I'm going to look at Pacer again. But the question was, is it common to wait until the last minute to file these things? And is there some kind of benefit to waiting? It really just depends on how busy you are and if it's done and what they were trying to do. So I can speculate though. It's not uncommon to just, it depends on the court. If the deadline is the end of day, like it has to be filed like in the mail before midnight this day, then it doesn't really matter. Sorry, my lips get so dry when I talk for over like an hour and a half. It's why I never wore lipstick in court. I always just wore lip chapstick. And tonight I was like, no, we're going with the Dior. It's so cute. And I love this lip glow, but it gets so sticky when I talk. So, but let me pull up, because I have speculation. Let me pull up Salty's Twitter and we'll go for speculation and then we'll check Pacer again. And then we might have to try this again, you guys. We tried. And then I'm going to have to change the title because people are going to be like, you're clickbaiting. It's like, no, we're actually still hoping this isn't going to happen. We're not trying to clickbait. Kim, Mary, happy. I love watching your videos. Thank you. I love doing them. It's as much fun as watching court. I hope so. More cursey words than court for sure. So let's pull up Salty's Twitter. I think, I typed in Salty to Twitter. No, that's not going to work. That's not going to work at all. So should just DM Salty. He follows me. I could make that happen. I'm teasing. Okay, so pinned comment from December 18th. Did KJ just say she intentionally deleted her whole Twitter account at the beginning of November because it was hacked? Interesting. Did she ever say anything about that? We know that she tried to say her Instagram was hacked despite having two-step authentication, but nothing on Twitter. Lots of answers there. And then there was a post. Oh, did KJ really say this? What video is this? So Miss Anon Mafoso, what was this? Did I miss this? I have not been on Twitter a ton. What is this?
There's a lot of stuff that's been put out by me that's just flat out lies, and it's for views.
Wait, did you guys hear that? Hold on, we're gonna get to this in a second because I'm trying to find a particular thing.
A lot of stuff that's been put out by me that's just flat out lies, and it's for views. There's a lot of stuff that's been put out by me that's just flat out lies, and it's for views.
Chat, let me know. Is there context here that's missing? Is like she reading an assumptions about me question or something? I want to know. Chat, I need you to fill me in on what the fuck that is. I have questions. I have so many questions. Fill me in. Fill me in. Oh, I should put this up because I haven't done it yet. Okay. There were this. This is the one I was trying to get to. Damn it. Emily, professional. This is why we don't drink when we're on stream. No, this is why we do drink when we're on stream, Emily. This is why we do. This was December 17th. To Washington residents that would like to share how they decided to not buy Halo products due to statements Ms. Paulson made about said products or the Westbrooks. We are trying to finalize declarations this week. Please DM or email to make final arrangements to submit yours. And then this is a December 3rd. If anyone from Washington State would like to sign a truthful declaration that they decided not to buy or support Halo beauty products due to statements made by Ms. Paulson about said products or the Westbrooks, please contact us to make arrangements. So Salty's firm was gathering declarations. And here's why I think they were gathering declarations, because what we gathered from KJ's motion to dismiss, let me pull it up because now I've got the business partner suit all pulled up and not KJ's motion to dismiss. What we know from KJ's motion to dismiss is part of it was regarding the company not having jurisdiction in Washington. So where is, and now I'm in the wrong suit. Where is it? Where is that motion to dismiss that I love so much? That's the face. That's the face. This motion to dismiss talks, and it's so hard to parse because the law is not clear. There's no law section. There's like the PewDiePie. Is this how we spell PewDiePie? Is it PewDiePie? Am I wrong? I'm just noticing that. That's a literally point of inquiry for the chat. I thought PewDiePie was PEWD. I can just Emily, you've got Google. Oh, look, I'm live. Oh, it is PewDiePie. Is it? Yep, sure is. All right, there we go. That's how we spell PewDiePie. I was just curious. I don't know if I've ever seen his name spelled. Anyway, I'm going to go back to the chat on right now. I need to sign one. I'm in Washington. Well, there you go. There you go. If you need to sign one, you can reach out to Salty. He was asking, I think they're trying to get declarations and they might have been working on that up until the end. And I will get into why I think they're getting declarations. And then we will jump back into the chat because I want to hear what you have to say about that clip that was on Twitter. So if you guys are in North America, by the way, you can join the text crew too and find out when I'm going live, because this thing's going to have to be filed and we're going to have to talk about it. Okay. So there is an argument about Bi Sister. There's an argument about Bi Sister. Where is the argument roughly about the company not having contacts? There's an argument. The trying to bring Star and Dawson into it. I can't wait to see what the response is to that. Like, I can't wait to see. Like, are we going to get a document that says, "Oh, you're right. let's sue them too"? I don't think so. But that's why I wanted to do a reacts live. I was hoping it would be filed. Okay. There is the business. Where is it about the business? Halo. Let's just search. Let's just search it. Of course it says Halo 216 times. Yes, we know. Okay. The complaint contains no allegations even suggesting this court may exercise personal jurisdiction with respect to plaintiff Halo's claims. Plaintiffs allege that this court has personal jurisdiction over defendants because they committed torts within the state, because they directly targeted plaintiffs who are residents of this district. If you said state here, say state here. With their tortious activity, the complaint defines plaintiffs to include the Westbrooks and Halo, but the complaint itself disproves the assertion that Halo is a resident of the district. Instead, it is alleged to be a Nevada limited liability company whose principal place of business is in Nevada. This is why I think they are going to bring in declarations of Washington residents who chose not to buy Halo products just to close that conversation. But I don't think it's really a huge issue because, again, plaintiffs can choose to sue where they want to sue. They just can. All right, let me go to the chat because there was that little clip of the video. Oh, it might come through right after. It sure as fuck might. But we've got a few more minutes and we'll check again. Court may have closed early for the holiday because of COVID. This is e-filed, so it'll get digitally filed and be populated on Pacer. The courts will be closed. The courts are already closed now and they'll be closed tomorrow. But if the deadline's today, it needs to be file stamped. Remember when we talked about the file stamp on other motions? I'll just use this one, for example, because it's pulled up. But you can see, oh, it doesn't have the timestamp on here like California does. So it just has the date. So it needs to be filed on the date. The California ones have the timestamp on them. Okay. So oh, yeah, I have. I'll come back to Pacer. You mean Salty hasn't changed his Twitter name to Salty yet? I don't think he would want to. I don't know. I should totally DM him. I love that Dior lipstick, but you're right. It gets sticky when I talk. It's beautiful if I'm just not talking that much, which when you're online, everybody tells me I need the Lunar Beauty lip gloss. I'll try it. I will definitely try it. KJ admitted she lies. Okay, I want to see what else. Motion for Salty to correct his Twitter handle. He probably wouldn't, and here's why. As he uses Twitter, we've seen from his Twitter activity that he uses Twitter to like talk about cases that are in the public forum and collect evidence. So he needs to accurately represent himself. And I could see, you already saw KJ saying, I'm going to make a complaint. You're violating rules of conduct. You're doing all of this. So you could see someone down the line saying, no, you're saying Salty. It's not clear that it's you. So it has to be clear that he is who he says he is because he is doing lawyerly things while he's on Twitter. Yes, he's allowed to have a Twitter, but he has to accurately hold himself out. Someone said earlier he was emailing it to you. No, I'm pulling it up off of Pacer, just like everybody else. If you guys want to be friends with me for Pokemon Go, if people are interested in that, let me know. We can do that. Yamino says it looks like there's a jump cut there. I wonder if the full video is somewhere. I bet it is. Oh, posted a longer version down in the thread. Okay, let's pull it up. Since we're here waiting for Pacer anyway, let's pull up the longer version. It is raining so hard. Oh, let's pull up the longer version down in the thread. A bit before and a bit after for context. Thank you. Let's pull that up. And then we can just we'll definitely chat about it. Let's chat about it.
Like if this happened to you. Like if this happened to your channel, and this is my other call to other, some of these smaller channels, like you might be gaining views on all of these stories, which is fantastic. Like I want your channels to grow, but my caution to you.
Really? Okay. We'll see. Let's see.
Is what I didn't know going into this is once you get bigger, this kind of stuff can and will happen.
I'm just going to say that once you get bigger, this kind of stuff can and will, and I'm assuming what she's going to say next is happen to you. It can happen to you if you are not a channel. This can happen to you if you make statements like this in a public way, whether you have YouTube or not. This can happen to you if you have 3 followers on Twitter and slander someone or libel someone. Defamation can happen. It doesn't matter if it is a channel, and it doesn't matter the size of your channel. If defamation said to 2 people can be defamation, remember Kesha got sued for defamation for 1 tweet sent to Lady Gaga, to 1 person. I mean, it was Lady Gaga, but it was 1 person, and it was found against her, even though it was distributed to one person. So size of channel does not matter. I disagree with that recitation of this can happen based on size of channel.
To you. So just because you're sort of in the safe little bubble right now, no one is immune to this. So
well, that I agree with.
Just be mindful, all of us, of like the kind of stuff we're putting out. Like I have never advocated for anyone to report anyone or do anything like this. And I want my community to just get back to being a community. I want the hate to stop. I want the hate messages to stop. Like if you don't like me,
hopefully there aren't hate messages because of this though. Like there shouldn't be hate messages because of this case. And hopefully that's not the case. I'm blocked and don't follow her, but hopefully there aren't hate messages because of this case. This is stressful enough. So this will happen. But this is stressful enough. There shouldn't be hate over this case. If she does other stuff and people dislike it, I'm sure they'll let her know. But over this case, it's like you're being sued. There's a suit. Like just, it's going to happen. We're going to see what happens.
It's fine. I'm not going to have a physical mental breakdown. I'm not going to spiral. I've actually been very calm the last few weeks. I'm still going to remain calm. And at some point, just realize there's a lot of stuff that's been put out by me that's just flat out lies and it's for views. There is some actual stuff out there that I listened to, received, and have completely changed my tone, my presentation, and everything.
I mean, that's a rough statement that's probably going to come in at a deposition.
Out there that I listened to.
Hold on. Am I missing something?
Still going to remain calm. And at some point, just realize there's a lot of stuff that's been put out by me that's just flat out lies and it's for views. There is some actual stuff out there that I listened to, received, and have completely changed my tone, my presentation.
That's going to be very interesting at deposition to try to explain what was meant there and how it was misconstrued or if it's a slip or what have you. But the reason we went to Salty's Twitter is because Hawaii, wonderful for your vacation, Salty. But because I think that there are probably declarations that they were working on in the context of, is this filed yet? Let's look at Pacer. So, I don't know. There are more clips. So, I don't know. That will probably come up in a deposition where she will have the opportunity to explain what she was saying and what she meant. So thank you guys for letting me know there was a longer clip. That was a clip video from a red script that she fumbled a word. Anyway, I think that she misspoke talking about what people were saying about her, maybe, but I think she meant to say about me, not by me. It's still going to have to be, this is the problem with talking on video, and it's still going to, that will be explained. I don't know the rest of the context of the video, but that'll be explained. So that's going to be interesting. And yeah, it might be a word fumble, but but in the middle of a lawsuit. And this is a good example, and no shade to her, but this is an example of why attorneys generally say, do not keep talking if you are in a lawsuit, because stuff can happen. And at some point, a jury's going to probably hear that if this goes to jury trial, and then a jury's going to decide if she meant it or not. And Irish Badass said the stream that's clipped was titled Lies About Me. And it sounds like people are saying I just lie for views, but that's not the words that were said. So if that's what comes up at deposition, it's going to come up. But then people will have to decide, and a jury will have to decide. This is just why lawyers say, don't talk. But this is also why you can't delete your shit, right? Because things like that happen and they need to be discussed. This is why lawyers say don't talk. Lavender, love your videos. Have you ever accidentally cursed while in court? No. Off topic, but I must know. So glad I caught this live so I can support you. Thank you so much, Lavender. It's almost 10 o'clock, so we're going to have to wrap up if this isn't filed. It wasn't edited, but she misspoke. And this is why you've got to be careful when you're in a lawsuit, when you're on video, because if it's a word fumble, it's going to still have to be explained, because you can imagine a situation where that clip gets played and the lawyer's like, but don't you? But don't you? And it's like, no, I misspoke. That's what people are saying about you. Oh, are people saying it about you because that's what you do? Like, I can see how that cross-examination plays out in front of a jury. And then if she gets agitated and mad and misspeaks in front of a jury, then they get to decide, which is why lawyers say, don't talk. Talk less. Smile more. When you're in a lawsuit, that's basically all you can do. Oh, living sweetly, Merry Christmas. Christmas wishes to you and yours for happiness, health, warmth, love, and a safe holiday season. Thank you, living sweetly. And I think those are kind wishes, and I'm sending them to all the law nerds too. Great wishes to everyone for happiness, health, warmth, love, and a safe holiday season. I think that's perfect. Oh, my nose itches. She definitely said it, Freudian slip. Oh, we're going to see. Tassie said KJ meant to say there are lies put out about her, but she said lies put out by her. Again, thank you for that. And thank you for the clarification. Because again, I'm not going to say, oh, this meant this and this meant that, but it'll be interesting because now it will have to play out. And that's going to be interesting. So Cassandra said that's a complete and total lie. She took LB's channel down and called for it to be mass flagged. And I've heard that. And I've seen a lot of people say that. And I think that kind of stuff's all going to come out. So thank you guys for clarifying. You guys indicate she had CPS called on her. That's unfortunate. And if this was coming along when that was going on, that's unfortunate. So I find the lawsuit documents, Jared, on Pacer, which is the government site. I also sometimes pull them from the local courts, like with LA County. I'll pull them from LA because they're not on Pacer because it's federal. Jesse said, if she corrected herself right away, would her statement not be as bad? Again, this is stuff that can go to a jury, and the jury will have to decide. When we talk on video, people can misspeak. But this is, again, why lawyers say, when you're in a lawsuit, please and kindly shut the fuck up, and that's hard to do when you're a YouTuber, right? And I totally get that. So it will be a thing where there will be a conversation about it, I am sure. And that will be a conversation had at deposition. And if it goes to trial, a conversation had in trial, and the defense attorney will be like, Salty is not the defense attorney. He's the plaintiff's attorney, but he'll be like, but didn't you say it because it's true? Didn't you do all this? And then her attorney will be like, but weren't you talking about what people say about you? And hasn't your channel been targeted? So there will be a back and forth, which is why court is a back and forth, to get to the truth in the middle. Alan said, hi, I don't really care about the drama, but I love the legal side. It's totally fair. We learn law through pop culture and news. Plus got a COVID test Tuesday, and thanks to Christmas, won't get the results until Monday. Stay safe. Have fun while an elephant sits on your chest. If an elephant is sitting on your chest, that's probably not good. Not a doctor, but it just sounds really uncomfortable. So Alan, take care of yourself. I know there are numbers of you in the chats who have had and recovered from COVID. So warm thoughts. Melody said she hasn't been home in the last few weeks. Oh, that's true. That was not good. I want to make sure I get to a few more questions. I'm going to check Pacer one more time, and then we're just going to have to go if we have to go, and we'll have to do this another time. Thank you, Annette. Let's see. You guys are having conversations with yourself. Michael says, COVID survivor. Diva Views says this is wrap up number 2. Yeah, that's probably wrong. Amelia, does KJ really believe? And again, I'm not going to speculate on anyone's mental. I don't think most people know what it's like to sit through days of depositions like that. It is tremendously taxing. Attorneys get used to it, but it's tremendously taxing. I could see her being in, depending on how many videos and how long the videos are, I could see this being weeks of deposition, not days of deposition, weeks of depositions. Real life with Michelle and Rob. Do you think KJ's attorney is mad at her? Can he tell her he isn't working for her? I would never kind of speculate what goes on with attorney-client relationships because it's so specific to them. I am sure there have been conversations about how to be careful, how to not talk about the case and things like that. But at the end of the day, the attorney doesn't have control over what you do. And I've seen this, taking it out of this context, I've seen this with attorneys who represent celebrity clients being like, I told them to do the thing and they didn't do the thing. I've told them, I'm sorry. I don't live with them. There's only so much I can do. So I've seen attorneys be tremendously frustrated. But attorneys can't always just leave. My hair is driving me crazy. Attorneys can't always just leave if they're in the middle of a case because a court won't always let them. They can ask to be relieved and a court can be like, no. And a lot of attorneys won't, especially, it just depends on how detrimental the attorney perceives it to be, because their case strategy is not something we know other than what we've seen filed. So their case strategy might still be, she's a YouTuber and this is all bullshit, so she can say what she wants. That might be their case strategy. And then in that case, they just don't care. And that might be the thing. So let me see if there is, yes, Kendra, thank you for the wishes. The chat jumped as I went to do this. Yes, the response isn't up yet. How much money do you think KJ is going to shell out in legal fees? I mean, these are expensive cases. So this can be hundreds and hundreds of thousands of dollars before you get to trial. So this can be a lot. I think I missed a chat because the chat just jumped on me. Christina, in Tati versus Without a Crystal Ball order regarding preservation of evidence, plaintiff's motion to preserve evidence is termed as moot. Oh, please explain. I can explain. I can explain. Oh, y'all with your COVID, stay safe. It is almost twinkle, twinkle time. Jakes, thank you. Oh, it's 10 o'clock. I think my youngest is probably asleep. That's why I normally stream at 7 so I can put them to bed. He is probably already asleep. So let me pull that up and answer that question, since there's nothing on Pacer just yet. Let me refresh it one more time. Let me see if anything's been updated. Nope. I swear to God, you guys, this is going to get filed at like midnight Central Time. We're going to have to talk about it in the morning. Which is exactly what Diva's like, no, we can talk about it in the morning. And I'm like, we're going to go live. It's going to be good. Diva's like, we can talk about it in the morning. Diva was right. It's not up yet. Okay, let me pull up the stipulated order. And so what happened, Christina, is that there was a stipulated order. And because there was a stipulated order, the motion on calendar is moot because the judge doesn't need to hear it because it is now irrelevant because of the stipulated order. And I hadn't pulled that one up yet. So stipulated order to not delete your shit. And this is now signed. So it says proposed on this one, but it's now signed. So here's what happens. Because they agreed, and this is now lined out and signed by the judge. I just didn't download the new one because the judge signed it the next day. But because they agreed to not delete shit, and then this was the order to not delete shit. This is what was agreed upon. The two attorneys got together and said, we agree on this. Because really, they're not agreeing that she improperly deleted shit. They're not agreeing that they can't file another motion for sanctions or for jury instructions. They're just agreeing here that nothing's going to be deleted on social media, video, live streams, comments on social media posts that are likely or could reasonably be expected to lead to the discovery of relevant information in this matter. And then they are ordered to preserve all published content within their custody. This is for KJ and Without a Crystal Ball, or control that they have or reason to know is either relevant to this matter or could reasonably be expected to lead to discovery, including without limitation. And then it goes through the things. Direct and instant messages sent or received by defendants, emails, text messages, phone messages. Defendant's failure to comply with this order can lead to sanctions. This order does not preclude plaintiff Tati's side from seeking discovery sanctions if and to the extent defendants have violated their duty to preserve evidence, those kinds of things. So the reason it's moot is because it's like, no, we've already handled that. We agreed. It's like when your kids sort shit out for themselves. We all agreed that we're cool. And the judge is like, good, I don't have to rule on it because it's already done. So Yep. That's why it's moot. So it comes off calendar and that's what it is. All right, let me see if I missed anything else. And then, oh, my chat just jumped again. Let me see if I missed anything else. Jerry said, so I want to stay, but I have to catch up on all my videos first. I know. Well, I'm going to be logging off too because we have just got to go. It's getting late. And we're going to have to see. Let me see if there's any other questions. The motion to delete is probably hard, but again, there's always the option to just not put shit up and not post it. So that's always an option. Because if you don't post it, it can't be deleted. Just saying. So Uncivil, it's good to see you. It's good to see you in the chat. I saw you in the chat. Thank you for being in the chat. Thank you, Jake's Baby Cakes. I appreciate it. You guys, it is late. It is late. It is late. Emily D. Baker, don't you have to use your actual legal name on court documents? Oh, yes. However, if you are a business and other things, you can, and if you have another name, then it just depends on what your given name is. So it just depends. But generally, yes, it's hard to answer because there are like quirky situations where you could say, well, the business name is this and the given name is a nickname and we know it is a nickname. But generally, yes, and it can be AKA'd later and it can be AKA'd because in the motion to dismiss, they refer to Katie by a couple different names. It would have been filed by what she held out in the public and what Tati and Tati's legal team believed her name to be. Or the name that she used on like her corporate filings. But in her motion and declaration, she used like 3 different spellings, or they used 3 different spellings of her name. So those could all end up being AKAs. Who knows? We'll see. I can't stay up either. I saw somebody saying, I can't stay up. We have to go. We do. Real life with Michelle and Rob. I will tell them Merry Christmas. Lindsay says, is it possible that if Salty doesn't have copies of the things she may have been successful in keeping them from evidence, they need to win? We'll see. I mean, they would file it. I would imagine they would file it, and this is speculation. I would imagine they would file it confident in the videos that they had seen and confident that they can win on some of these. They don't have to win on all of them to win this case. They can win on 1 or 2 statements. They could win on tweets versus videos. They could win on video statements. There's a lot of ways that they can do that, but they are going to have to prove damages. And I think we'll see some of that maybe being alluded to in this motion because the jurisdiction is attacking the company's jurisdiction as well. So we'll see. How is Tati going to prove damages? Blake, we will see what they show the damage was and the timing of the damage, because KJ's side is trying to be like, bye sister, you wrecked yourself. But I think a lot of us saw with bye sister, she then launched Tati Beauty and the launch sold out. She launched the Blendiful after that. And she gained subscribers off of the back of bye sister, which, distasteful though it is, happened. So, all right, guys. We are going to, I saw another question. As much as I think KJ defamed Tati, I don't think she can prove them. And we'll definitely see. When it comes to public figure, it can be more difficult. But some of the statements against James might be defamation per se, because they can win against James. Like, even if the statements against Tati don't win, you could win against James and you could win against a Halo Beauty if some of the Halo stuff's proven. So there are definitely ways to do it. All right, guys, I'm going to get one more. Thank you. You guys, it is late. We're going to check one more time, but I don't think it's up yet. We're going to have to talk about this tomorrow. Tomorrow's Christmas Eve. It's Christmas Eve. I had no intent. It's not up yet. I had no intention of being on the interwebs tomorrow, but we might just have to. We might just have to. Is Uncivil or Ricada or anyone else streaming tonight? I'm still wrapping gifts. I think Uncivil's in the chat, and maybe I have to go wrap gifts too. So you guys, I will see what happens. I'm going to check. The mods had something. I'm going to check in our mod chat real quick. And hopefully this will be filed soon. We'll talk about it tomorrow. I was optimistic. I was optimistic. Oh, Nick's here too. Hi, Nick. I don't know if Nick's streaming tonight, but if he's in here, he can say it. Just Jen's like, see you tomorrow. I mean, if no one's traveling for the holidays, everybody's like, it's Christmas Eve. We can have a chat in the morning. If Nick's streaming, he'll be streaming late. Uncivil Law is like, I'm awake. What time tomorrow? Let me see if this gets filed. Cause you see what happens when I'm like, it'll be in. We'll just schedule it. It'll be fine. So let me see. I'm going to talk to the mods. The mods are off tomorrow, and it's hard when we have 4,000 and 5,000 people on stream without mods, and it is Christmas Eve. So I'm going to be mindful of that. So I'm going to have a chat with them. I can always record something and put it up so we can talk about it and then live stream after the holidays. So we can figure it out. I'll have a chat with them before I let you guys know that. They are going to remind me to go ahead and like the video. If of the 4,500 of you that are here, thank you for spending your evening with me. If you have not subscribed, go ahead. Where are we at? We're at 70.7. You guys, we're getting close to dyeing my hair purple. That's going to happen at 100,000. What is coming up from me? What's coming up from me is that we are going to have the video version of the podcast go live. I'm almost done editing it. We had some technical difficulties, and that'll be live. I'm not going to premiere it. I'm going to put it up for you guys to watch and enjoy. It's a little bit of a longer one. I'm celebrating 100K downloads on the podcast. I'm like, thank you for 100,000 downloads of the podcast, which was really exciting. I am not intending to be back, except now this is late. I'm not intending to be back on stream until Tuesday's Coffee Talk Live. I will talk to the mods. I can always pre-record a video and put it up for y'all so we can figure it out, because I do want to look at this motion and kind of do hot takes. I'm very, very excited. Diva, you're so sweet. Yes, go ahead and DM me on Twitter about Pokemon Go. We can be friends. I love that you guys are like, I volunteered a mod tomorrow. I appreciate it, but I had promised the mods that we were done today and that I will talk to them. But if not, we'll get a video up one way or the other. Also, if you guys don't follow me on social, come follow me on social, because if I decide to do things last minute or go on Instagram and do a kind of first look, then we don't have to mod the same way. And I can always go on Instagram and do a first look of it and then film a video and put it up for you. But the video for the podcast will be up. I have another video to be up. So there will be videos up, but they won't be premiered. So we won't have live chat. They will just go up. And then I'm recording another ASMR video for you guys, but I am taking some time down for the holidays. And that is a good thing. Uncivil's like, I'm staying up for a while. If it posts a pacer, we will do it live. All right, Uncivil, DM me. I will be up for a little bit too. I'm going to go check in on the kids. I mean, I'm going to be editing, so I'll be up. I love Uncivil's like, I'm down. We ride at midnight or whatever. And Ricada is probably like, yeah, I stream till 3 a.m., so it's fine. Everybody's like, we're down. There you go. I will talk to you guys. I will keep you in touch. And if Uncivil goes live, I will let you know. If Uncivil gets Emily bombed by me, I will let you know. But it is hard to keep the mods after a 2-hour stream and then do more. So I want to see Uncivil bang his head. We can do a lawyer hot take. And then Uncivil and I talked about doing a panel talking about this with Nate and everybody, so that we could just have everybody reacts. So I will talk to you guys later. It's late. I appreciate you. Do the YouTube-y things. Subscribe, all the stuff. Thank you guys for the super chats. Thank you for hanging with me tonight and being patient with my 11 a.m. video that didn't go up today and being here for a late night. Thanks, Uncivil. I mean, we'll see. If this goes up at 2 a.m., I'm gonna be asleep. I have to go wrap some presents, though. We're going to do that, too. Thank you guys for being here. I appreciate you. Law Nerds, you are the greatest, and I appreciate you with my whole heart. I will see you soon. Have a wonderful holidays. For those of you that celebrate Christmas, have a great one, even though it's a weird one. Just enjoy the season and some downtime. Connect with me everywhere. I'm at the Emily D. Baker. The podcast is the Get Legit Law and Shit podcast. So if you're ready to ride at dawn, head over to lawnerdshop.com, your place for all your law nerd needs: stickers, t-shirts, sweatshirts, and more coming soon. If you guys want to join the text, just textemily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube